हम्म
हम जा रहे कोई और कॉन्फिडेंस है थोड़ा ऐसे लिखना है वही मीटिंग करेंगे लोग पता चलेगा सर सही बात है देख लो उसके बाद क्या मैसेज सॉरी आई गॉट बीसी आई हम जा रहे कोई और कॉन्फिडेंस है थोड़ा ऐसे लिखना है वही मीटिंग करेंगे लोग पता चलेगा सर सही बात है देख लो उसके बाद वो भी है और क्या मैसेज
जल्दी हो गया था
सॉरी आई गॉट साढ़े यू डोंट नीड मैटर आ ही रहा था थोड़े पहले
अच्छा तो जल्दी हो गया था सब कुछ
3:30 तक आया तो ले लेते यार पर अभी तो काम से मतलब है अरे जब तो ले लेते अरे तो ले लेते यार अभी तो काम से मतलब है अरे जब साढ़े 9 ले लेते करने तुम्हारी कोई हेलो कुछ करने की साढ़े 9 तक कुछ करने की तुम्हारी कोई
Good morning, sir.
Good morning.
Sir, will you mention or you are any item number, sir? Item 3 and 4.
So
Fine.
item 3 item.
Fine, sir. Thank you so much. Good morning, sir.
Good morning.
Sir, will you mention or you are any item number, sir? Item 3 and 4.
So
Fine.
item 3 item.
Fine, sir. Thank you so much.
Who appeared in this judgment?
We appeared, my lords.
You appeared for
The petitioner, my lords.
the insurance company.
Yes, my lords.
Perhaps the insurance company
Who appeared-
not like
who
this
appeared in
judgment,
this
judgment, but
You
may
appeared,
be
my
to
lords.
settle the law. You appeared for
petitioner.
in regard to the insurance company of the
Yes, my lords.
litigation. Perhaps the insurance companies may not like this judgment, but we have to settle the law. In regard to the final nature of the litigation, you have addressed as a bar to invoke arbitration. Secondly, the scope and standing towards the full and final an application under section 11 operate as a bar 6 of the Act 1996. Secondly, can be subjected to when a plea of scope and accord and satisfaction is taken by that an application under section 11. What is the effect of the Act 1996 in re can be subjected to when a plea of under the Accord and Satisfaction and Conciliation Act 1966. And thirdly, and the Indian Stamp Act of the decision of this court in on the scope of powers of the arbitration agreements under section under the arbitration of the Act and Conciliation Act 1966 and the Indian Stamp Act 1899. What we on the scope of powers of the referral court, even if the contracting parties, in pursuance of a settlement, agree to discharge each other of any obligations arising under the contract. Thus, even if the contracting parties, in pursuance of the arbitration agreement, agree to discharge each other of any obligations, unless the parties arising under the contract to do the same. This does the intention of the parties in discharging a arbitration by agreement to would come to an end to relieve each other unless the parties of the existing agree or any new obligations under the contract. The intention of the parties in discharging a contract by accord and satisfaction cannot be construed to mean of the parties also or any new obligations under the contract of their obligation to such a discharge of obligations pertaining to the original contract through arbitration cannot be construed to mean although ordinarily the parties also intended to relieve each other of their obligation to settle any full and final settlement pertaining to the original contract dispute pertaining to the full and final settlement although ordinarily by necessary implications may being a dispute arising out of a full and or in relation to yet or any dispute pertaining to the full and final settlement itself from reference to by necessary implications as the arbitration agreement arising out of contract or in relation continues to be in existence or under the substantive even after the parties have not been precluded from original contract to arbitration by accord and as the arbitration agreement contained in the original contract continues to be in existence even after the parties have discharged the original contract by accord and satisfaction. The existence of the arbitration agreement as contained in clause 13 of the insurance policy is not disputed by the appellant. The dispute raised by the claimant being one of the existence of the arbitration agreement as contained in clause 13 of the insurance policy is not disputed by the appellant. The dispute regarding the dispute raised by the claimant as raised by the appellant does not of liability to the existence of the arbitration agreement and can be adjudicated upon by the arbitral tribunal regarding as a preliminary satisfaction. For all the foregoing reasons, does not we uphold and affirm the existence of the arbitration agreement and can be adjudicated upon by the arbitral tribunal as a preliminary resolve the disputes between the for all the foregoing reasons. We uphold and affirm what is important in this judgment is that we have clarified as an arbitrator to resolve our earlier judgment parties. But in Arif Azim, what is important in this judgment is the clarification starts we have clarified para 126. We have explained how Arif Azim should now be construed or understood, more particularly in light of clarification starts from and para 126. What is important is we have explained how Arif Azim should now be construed or understood
very quickly, we
more particularly in light of thus we clarify that while determining the issue of what is important in exercise of the powers under section 11(6) of the Act 1996, just one paragraph very quickly, the referral code should limit its inquiry to examine that while determining the issue of limitation in exercise of the powers under section 11(6) of the Act limitation of 6 years or not. The referral code should limit its inquiry to examining for this purpose. Section 11 shall have to be subsection 6 as per the decision in filed within the period of as a natural corollary. Or not. It is clarified the date of the commencement of limitation period at the stage of deciding an application shall have to be appointment of arbitrator as per the decision must not conduct an intricate as a natural corollary inquiry. It is clarified that the referral claims raised by at the stage of deciding an application should leave that question for determination must not conduct an intricate such an approach gives true meaning to the legislative intention. Claims raised underlying by the section 11 time bar brackets 6 and should leave that question for determination by the arbitrator. Such an approach gives true meaning to the legislative intention underlying section 11 bracket 6 capital A of the Act and also to the view taken in re interplay. That's how we have decided. Thank you.
Very good. Very good.
With your lordship.
May I just give a lordship?
Everybody else, please circulate emails because once we breach the norm, then I cannot breach it only for seniors and I have to do that for everybody else. It completely destroys the system which I have put in place. Everyone who has a request, please send me an email.
With your
May I just give a lordship?
Everybody else, please circulate emails because once anybody who does not have a listing request, I cannot breach it only for seniors and I have to do that for everybody else.
There's a matter coming tomorrow, we
It
are asking
completely
the review
destroys the
today
system
to be
which I have
put with
put in
that
place.
tomorrow. That's
Everyone
a
who has
request.
that also has to
I'll
go
put
on an email. That's
Yes,
I'll look at
yes,
it by the
yes.
afternoon.
This is not a
Listing, if it's on listing, please don't, anybody who does not have a listing in an email, I'll look at it in the afternoon today. I promise you I will do that.
There's a matter coming tomorrow, we are asking the review today to be put with that tomorrow.
When was the implement order
That's a
passed?
request.
That
I
also
can't
has
put
to
in
go
a-
on an email. That's a
Your
listing.
lordship,
I'll put it in the email. Put it in the email.
Listing, if it's on listing, please don't mention. Please put it in an email. I'll look at it in the afternoon today. I promise you I'll do that. It's the same thing.
Now my difficulty is building may be demolished.
By 19th, right? So we'll list it tomorrow.
Your lordship, I'm just
I'll
seeking
list it tomorrow.
permission to
No,
circulate.
but you could have also said it in an email. Sorry. Circulate a rejoinder.
Circulate a letter in tomorrow's matter listed at item 26 and for the respondent, you just need
Too
some
late
time to
now.
come.
We'll see tomorrow, yes.
Because I'm mentioning a matter where I've already sent emails, Manoj. I've also sent
It will be
emails
dealt
this
with.
morning.
It will be dealt with.
This
Puneet,
morning
just
also,
make
Manoj,
sure.
I'll meet the.
Mr. Shoaib,
Manoj, my request. Very great.
Just a query, would your lordship be taking the part third income tax matter or?
Just
would your-
wait, I've just told the court master, we'll tell you in a minute, yes.
My lord, sorry, I just one request. There's an order that your lordships had passed last week, my lord. It's an arbitration petition. Your lordship perhaps will recall, my lord, I had made a submission that the pendency or the reference to arbitration will not impact any criminal proceedings that we might initiate. Because our recollection is my lordships had dictated that in court, my lord, but it's perhaps not reflected in paragraph 3, my lord.
No, your lordship,
We also said in the course of the discussion
Please, my lord.
that an arbitration will never affect a criminal prosecution.
But I made that submission, I think.
All right.
Your
We
lordship
don't have to
had
put
made that
something, we
observation.
don't have to put something, clarify something which is obvious.
Very well.
So before we begin, what we're proposing to do is that we have the income tax partnered group. NEET is above that today. We'll at least open the NEET matter and then we'll see what to do with the partnered group. We'll hopefully start with the partnered group, but it might just have to wait until we open the NEET matter because there's some urgency in the NEET matter. Young students all over the country are waiting for the outcome of this matter. So, but we are not going to lose season of the income tax matter because we are now also mentally we are in the matter.
But may I suggest, since we have circulated something yesterday, it can be kept tomorrow also.
Let's at least open the NEET matter today because, let's see the matter.
The others can be discharged, etc. Many are procedural matters, item 4, etc.
So what we are doing is, seal number 1, for instance, is about bifurcating. We'll take up item 1. So it's bifurcating matters, etc. That will pass procedural direction.
4 is for compliance like that. When your lordship
Right. We'll just say yes.
I'll point out.
Item 1 is not bifurcating. Item 1 is a batch of cases on fringe benefit tax.
Yes, the fringe benefit
come on
tax.
some other day. Yes. The bifurcation is the gaming matter, I think, if I'm not mistaken.
Why is that listed for directions? Because item 1 is only listed.
But there are two appeals.
All right, then
the
item 1,
petition.
right. The courtmaster says that, we have to pass the usual procedural direction for appointing nodal counsel so that they prepare one common compilation. So tell us who will be the nodal counsel.
That's right. Mr. I'll give my AOR's name to your lordship's bench, and one from the department. So 2 of us can be there.
Is
We'll give
there
you
a
by lunchtime.
compilation for the department? Is there a compilation for the?
Only for the
So now tell us for the petitioners, who will be the nodal counsel?
I can volunteer.
Mr. Kunal Kishore can one.
Ma'am, since you have already prepared.
Anisha Karya have already our compilation.
And for the department, Mr. Venkatraman, are you appearing in the one? You are appearing. Who will be the nodal counsel there?
Mr. Divakar.
Mr. Divakar. So Ms. Manisha Karya and Mr. Divakar will be nodal counsel. Usual orders. And prepare one common compilation duly indexed with written submissions in terms of our last circular. And file it by what date will you file it? Mr. Datar, by what date will you file the compilation?
Your lordship is posting it in August or July?
We'll post it in August. So we'll give you enough time to file the compilation. You can file the compilation including written submissions by the 31st of July and we'll place it in August. All right. So that seal number 1 is over. That way, we have just one compilation, otherwise it becomes impossible to.
Item 2, Millard, the canon matter, Millard, they have put a direction now. It has to be, bench has to be constituted, the after batch of matters there.
So here also, can we have one compilation, please?
Yes,
we can do a compilation.
Right. So who will be the nodal counsel?
I will.
Charanya will be the.
From our side, V. Chandrasekhar Bharti will be the
So.
panel counsel.
Charanya Lakshmi Kumar and Mr. V. Chandrasekhar Bharti. And can you prepare the submissions and compilation by 31st of July?
No, definitely.
Definitely.
Then we'll keep it in the first week of August and we'll take this up because a lot of matters across India are dependent on this.
Pending.
Thousands.
Thing is, you may remember because this matter, the canon matter was passed by 3 judges.
Right.
Therefore, it has to be.
It has to be 3 judges. It will be before this regular bench.
Yes,
it will be before me and my 2 colleagues. So we are seized of the matter.
As it pleases.
Item 3 is the Google matter.
Manoj, I appear for Google. Your lordship recalls your lordship.
What we'll have to do is, are the compilations ready in Google?
Everything is done. Manoj, give dates in September.
Today,
Your
Mr.
lordship's
Sade,
fine.
only because we have the NEET matter and, literally lakhs of
No, Manoj,
all over the country are waiting for the outcome of this matter.
No, in September, Manoj. Give dates in September.
Probably in the first week of September so that we can conclude.
Manoj, a little later, I have the Indus Valley dispute before the neutral expert in September.
Second week of September, Marathon.
After 15th, Manoj. After 15th, any day.
Submissions have not been received, the courtmaster says. So you'll have to email them.
That will make sure, Manoj, are sorted
All
out.
right, why don't you give us on the side of Mr. Salve one nodal counsel?
Lordship,
Yes.
we have filed it. We filed it on the 3rd of October. We'll file it again. We'll send an email again. It's been filed.
All right, who's the nodal counsel on your side?
Mr. Chandelier, he's the nodal counsel.
Mr. Shandilia, and what about Mr. Venkatraman, your side?
Already said in
We've already appointed nodal counsel. All right, then make sure that is filed by the 31st of July. All right.
Yes.
gaming matter.
This again, my lord, is the gaming matter.
Are these absolutely ready for,
Union Mallots has filed its counter. Lordships are directed
Hello?
violations to be filed, appointed nodal council that has not.
102.
We can do it one of weeks.
so we set down 31st of July for completing the filing of the compilation.
Maybe 15th August may be better, Malad, but I'll leave it to.
Anti-profiting batch we can exclude, but amongst gaming, no segregation, my lord. Everything has to be heard here.
Agreed. My friend is right, my lord.
15th August may be better.
This exercise has been done in the registry.
Yes.
The gaming matters we've got separately listed and the anti-profiteering
Yes.
matters are separately.
Correct.
So
Lordship.
they have to be segregated. Now, what we will do is that the learned council can, this is being done by
The
Charanya.
list is made. Charanya has
Have
made.
you looked at it?
Just check it up, my lord. Just give it to me now.
All right, Ms. Charanya Lakshmi learned counsel appearing on behalf of the petitioners, some of the petitioners, has prepared a tabulated statement segregating into single invert commas, gaming into invert commas, matters from into single inverted commas, anti-profiteering matters. Full stop. The statement is reproduced below. Copy kar lijiye. Mr. N. Venkatraman, Learned ASG, states that he will have this duly verified within the course of within a week. And intimate the registry in regard to whether he agrees on whether the statement reflects the correctness of the statement. Full stop. This may be communicated to the court master no later than by date de dijiye on the email ID. The compilations are ready.
The counter was received by us in the writ petitions on Monday evening. So we need some time to file the rejoinder.
If a rejoinder has to be filed, that may be filed on or before 31 July 2024.
Lordship, some of the transferred matters, the councils indicated that they would also like to make written submissions when we checked with them. So they were waiting for direction.
All right. If any further written submissions are to be filed, including the transferred cases, they may be filed with the nodal council who will send to the common compilation. So the written submission shall not exceed 5 pages each. Because
would your lordship set it down on 31st for directions?
Absolutely.
Would your lordship have it on 31st for directions, my lord?
We'll have it on the 31st of July for directions. For the directions on the 31st, which is a Wednesday.
Lordship,
Taken first.
All right.
Directions.
We are segregating gaming and the two sets
anti-profiteering.
will be taken
There is
separately.
no difficulty in segregating gaming and anti-profiting. Now, any
That's all.
segregation within gaming is not acceptable.
No,
we are not asking for it now.
No, somebody last time said game of skill should be segregated.
Mr. Venkatraman, now you're giving them ideas.
Yes, correct.
No games.
Nobody is ready for now, Malad.
All right, now, so that covers 4, 19 and 20. So 31st of July, we'll keep it for directions.
Yes.
Just to ensure that everything is complete, then we list it immediately and hear this.
Great.
Obliged, Malad, obliged.
Lordship.
Matter, because this is for the gaming matter, now the counter, etc. we have prepared. For anti-profiteering matters, there are no directions in terms of
The circular.
permission to
So
file.
for the anti-profiteering matters, we'll issue similar procedural directions, same nodal council,
Can be then.
same nodal council, same. And by 31st July, that process must be completed.
We can do
All
that.
right?
Obliged.
That is neat.
Please below this.
Mr. Agde, we'll now stand back the income tax matters. We are not adjourning it for the day, but in view of the importance of the NEET matters, we'll take up the NEET matters, because but all the other learned council may step aside and you can have a little time off, but we'll take up the income tax matter because we're not taking up any other heavy matter until we take up that. So NEET only because of the social ramification, we thought we'll give priority to the NEET matter. All right, now.
They're all mixed up. 5, 7, 9 and all that.
Now, who's going to open the arguments in the NEET matters for the petitioners?
My lord, my item 5 is slightly on a different footing. I am showing not merely the leakage of the examinations, but I am showing the.
Because mine is the first matter wherein the.
Mr. Dwivedi, where are you appearing in this matter? Judge's pension matter. I think you're safe today because, if after this, we are going to take up the partner tax matter, which will take the rest of the day. So, but the judge's pension matter is again important and we will take it up probably next week. We'll list it and take it up. Just a little adjustment of the board, that's all.
So far as item
7, if Lord, I can,
the writ petition under Article 226 of this candidate is pending before Honorable High Court of Delhi. He has filed writ petition under 32 before this Honorable Court also, saying that I'll withdraw that. This is the third time consecutively where he is alleging that my OMR has been replaced, which is factually.
All right.
That
That we will see what to do there, because that's not about the systemic issue, but about his own OMR sheet. There we may be who's appearing. Which one is that? Serial number?
item 5. My Lord, in 514.
So five, why don't you do this? Go to the High Court. Whether your OMR sheet has been replaced or not, there is not a systemic issue.
High Court has already passed the judgments. High Court has refused to examine this issue. My Lord, I had delegated.
So why have you filed a writ petition? You have to file an SLP then.
No, my Lord, in 2020, I went before Honorable High Court on the directions of this Honorable Court.
But now High Court is held against you.
In 2021.
21 hoga, 20 hoga, 19 hoga, 23 hoga.
My Lord, since then.
But now tell us, what remedy do you have against that judgment of the High Court?
Against that, even if I come in SLP, my Lord cannot grant me an admission. My Lord, I am saying I reappear in the examination in the
Fair enough. We'll entertain your writ.
Yes.
On one condition, that now then we will treat the order of the High Court as attained finality.
Yes.
So we will then hear your writ on the footing that the order of the High Court has attained finality. So you're taking a chance.
My Lord, High Court refused to examine the issues. That's the final.
All right, we'll see. We'll see when the matter is called in.
My Lord, may I?
Mr. Nagamoto, we are seized of the matter. We know how important it is. It's about our own retired judges. But we have the NEET matter today, so we'll give priority to the NEET matter today. We just indicated to Mr. Dwivedi, we'll try and accommodate it sometime next week, so we'll take it up immediately. We'll just give me a little time, so I'll just in the evening discuss the board position with the court master, and then we'll fix it because we have to take it up.
My lord, I'm here for item number 6. I have the same prayer that my OMR sheet was replaced and the.
All right, let the matter open up now. If everybody just keeps on giving your individual fact, who's going to open the hearing?
Yes,
open the argument?
mine is the first matter, my Lord, where they have filed their responses.
So we'll hear Mr. Huda first.
Yes, my lord, I'll supplement whatever he is.
All right, and then we'll hear the solicitor.
Your lordships had an occasion to go through the second status report.
Yes,
TBA.
we have seen the second
Now
state.
that is something is crystal.
We have seen the second state.
Yesterday it was.
Yes, I saw it in the morning today. Both my learned brothers have seen the second status report.
May it please your lordship. No. This is yours. Just one suggestion. Okay. All my. Okay. That will be first play. My lord, in item 5, may I please request that the first prayer is, my lord, that.
You're not arguing it. You have somebody before you who is to argue his matter.
They are in item 7 and item 5. I am making a request.
But which is the lead prayer? Which is the lead matter? Are you prepared to argue the whole matter on the leak, etc.?
No, I'm on the not on the legal aspect, my lord.
Then why are you interrupting the flow of the proceedings? Allow somebody who is arguing the main matter to take charge, right? We'll hear you. We'll hear you at the end. No problem.
Since not replied. May it please, Lord. Lord, 2-3 things at the outset, Lord. As per my Lord's direction, CBI was supposed to file their status report. Filing, we understood it will be filed and it will be supplied to us. And that was the direction.
The only problem is this.
Pardon?
The only problem is this today. I mean, I'm all for transparency. In fact, this is not a sealed cover procedure. Let me be very clear. But today an investigation is going on.
Correct. I
Right?
quite follow that.
If what CBI has told us in the course of the investigation is revealed, probably the investigation will get scuttled because people will become wise on what are the leads which have emerged in the course of the investigation. So that's the only thing.
I bow down straight away. My only, you see, the intervention in between will cause a problem.
So what we would like you to do, Mr. Huda, is
Please.
you have to, you know, redaction is not possible in these kind. If it's redacted, then it'll have nothing of it'll have nothing of substance. You will have to show us prima facie on the basis of your submissions that the leak is so systemic and has affected the entire examination process across the country that we must cancel the examination and direct a fresh examination to be held.
Yes.
That is the area where we want to hear you. And then we'll hear the learned solicitor in response to that.
I will assess this honorable court
Then,
of that area.
just 1 second. Second, we have some ideas also on what we are going to post to the solicitor thereafter.
Please, Mr.
We would like you to assist us on assuming, if we accept your wider submission that you must have a fresh NEET examination, then that's what you exactly want. Suppose in the alternative, after hearing you both, we are not with you, then we would like you to also assist the court on which are the further lines of investigation, what are the lines of investigation which must be carried out, in the sense that which are the specific issues which must be investigated. So we would like your assistance on both. The other is an alternate argument.
Yes, but that alternative argument has also come in my supplementary note, which I circulated yesterday.
Okay, we'll
in the same matter, I have suggested that this is the line of investigation should be conducted to unearth this entire controversy.
All right, then we'll look at that. Later on, we'll read it with you.
At the outset, my lord, I was flagging my handicap in I'm assisting. I'm not saying that. But the handicap I have in assisting this honorable court in this leak matter, one, they have not declared the entire result. They have declared the result of 100 people. And my assistance is information gathered from here and there. The UPSC, my lord, in IAS exam, they declared the result of entire people. At least they should have declared the result of this 1 lakh people who get admission, first 50,000 in the medical colleges.
Just one second.
The two handicaps, my lord, may kindly notice, I will have in the course of my assistance to this honorable court.
First 50,000. How many seats in the government medical colleges?
56,000. And Lord, everybody clamor for these first 56,000. Even the people below 56,000 may be willing to go for a re-examination.
And how many in the private medical colleges?
52,000. 56 and 52. That is 1,08,000. Now, my lord, if re-exam happens, literally it is, if all of them do not want re-examination, the total number is 1,08,000 people, not 23 lakh people. The remaining 22 lakh people
have not got admission at all.
Have not got admission. So they are willing.
Except for the fact that if some people have wrongly got into the 1,08,000 category,
that's right.
Then somebody below the 1,08,000 can legitimately get into that 1,08,000.
Correct. That's right. So, but in fact, the balance is this 1 lakh. If all of them 1 lakh don't want re-examination, this 1 lakh on one side and 22 lakh on the other side, who would like to take a chance in view of the this examination is marred by controversy. All 22 lakh would like to have a second chance.
That argument,
yes,
Mr. Huda, there's a problem. Forget the question of leak in this matter. Merely because, say, out of 22 lakh, 1,08,000 only have got admission or would get admission. And therefore, you are left with, say, about 20 lakhs, 22 lakh students who would want to take a chance. We cannot order a re-examination merely because they want to take a chance.
Right. But I just
re-examination has to be on a concrete footing, that the sanctity of the entire examination has been broken.
I bow down. I just wanted to dispel an impression that the stake in the re-examination is of lakhs of people. No, the stake is of 1,08,000 people. I will have to set up, demonstrate conclusively that we cannot segregate tainted from the untainted. In Tanvi Sabharwal case and the judgment authored by Mallo clearly says in Tanvi Sabharwal's case, the finding was we have identified 44 candidates out of 6 lakhs. The remaining we are not able to identify. So we cannot permit even 10 people.
Mr. Huda, I think, you need not labor that point because you're absolutely right on that.
I'm so grateful.
That if you can, conceptually, that if you can establish that it is not possible to segregate the tainted from the untainted, then the whole examination has to go. Because those basic, you can of course show those authorities briefly to us at a certain point. But when we have looked at the facts, but before we go into the authorities, we want you to address the core of the facts before us.
No, my lord, I will try to first summarize my case and then elaborate.
All right.
So that my lord has an idea what I am saying.
You can summarize, ma'am. My brother Justice Pardiwala would like to know, out of 1,08,000, totally how many petitioners are before the court?
Lord, it is NTA can say, my lord.
NTA, 38 petitions. Yes. Now, you're for NTA, no?
Transfer petitions filed by the NTA, my lord.
So 38 petitions includes the 6 transfer petitions or transfer
petitions before this honorable court would include the 6 transfer petitions
All
filed by the NTA, my lord. So 32 petitioners, 32 petitions.
Our question is little.
How many? 8,000. I represent 10. I'm from
How many are asking
we can
for?
supported by 43 more from
Lord, I do not know how many, at least 100, the candidate must have called us individually, but who have not
I think they have a figure.
108.
108. Mr. Kaushik, if you can just ask somebody, any of your team from the NTA, to just do this physical exercise of telling us even at lunch or after lunch, how many total students are involved in the matters before not involved, but how many students have moved the court in this batch of cases?
Lords, with utmost respect, my lords, that may
Approximately 108 are seeking reconduct of the examination.
The council,
50. Yes.
108 who are seeking re-exam are amongst 1,08,000.
No.
Yes. Yes. No,
they'll be outside 1,08,000.
We are outside 1,08,000.
They plan to be.
Because 1,08,000 would get, they have succeeded.
They have not seek re-examination at all.
I represent.
So all those who have not been able to
Yes,
clear.
yes.
Some people within 1,08,000 are also before your lordships because they say
they will not get into government medical.
They will not get into government. They will get into it.
My lord, in my petition,
seeking re-examination.
my petition 700. In my petition, my lord, there are 5 candidates. One of them.
Now in charge, unless we ask a question to some other council, the others may not interrupt because otherwise, our line of thinking is also affected. And he's deflected also. He has his thought process in some matter. Yes.
Students out of total.
But they are not in mission.
I'm on your side, ma'am.
Also, Brother Manu Mishra had a point. What is the minimum mark which has been received by the petitioners before the court? We just want, you need not give us an offhand answer. Just do it at lunch and tell us.
My lord, can I one thing, my lord? In 5 petitioners in my petition, my lord. One is having, my lord, 700. Another is having 600.
How will we be able to just wait for a minute? Let's have the conceptual basis of the matter. We can't go in individual facts like this. Let's have the concept very clear before us, and then we can see where the balance lies. Yes, Mr. Ola. We'll hear you. We're not going to run away. We are here to hear you and do justice to the matter.
Roughly, qualifying marks are 164.
Done this exercise. There are 131 students who are not falling within 1,08,000, and they are playing for retest.
131 students.
130. And petitioners, and there are 254 who are falling within 1,08,000. They are opposing them. Not that statistics can assist your lordships either way, but factually this is the position.
So 131 students beyond 1,08,000 who want a retest, and
254, they are in the form of IAs for implement.
Who are opposing?
For opposing the retest.
They
fall within 1,08,000.
The figures may not always be right, my lords, because I represent somebody who falls within.
Yes, that's true.
And whose rank is about 2009. But, my lords, we'll work out the figures in common with Mr. Kaushik.
Now tell us also what is the cutoff rank for the 56,000 and for the 1,08,000.
May just one clarification conceptually. Anybody who is above the 50th percentile qualifies, in the sense that if somebody above them also does not go into medicine, goes into IIT, for instance, there will be a figure. So passing is 164. Passing is 164, but admission is a dynamic process, may stop at 1 lakh, may stop at 1,50,000. And depending on the particular quota or reservation or whatever is available. 164 is the cutoff mark. 164 means that you are above the 50th percentile. So about half the people have a qualification to be allotted a seat, but not everybody will be allotted a seat. So it's a dynamic process. There is 1,08,000 seats available. Some of them may not opt for medicine, some may go into IIT, this, that, and the other. The figure will come down. And also depending on whether you have a reserved category or something. So it is not, so it is dynamic, but roughly saying, I think the last figures will stop at 2.5 lakhs, rank-wise. That's
well, let's hear Mr. Hudana. Yes, Mr. Hudana.
So, my lord, I'm starting.
You can summarize your case, you said.
Yes, I'll just summarize. But it will give me a space, please. Lord, I'm starting with a handicap. I do not have the result. Because of that, I cannot have the data analytics, which the state has placed, NTA has placed on record, giving the bell curve. And Lord, one of the director of IIT Madras is a member of the governing body of NTA. They have run the data analytics process, taking the entire number of 23,33,000 candidates who sat in the examination. If data analytics is to be run to 23,33,000 people, at what stage 10,000 or 20,000 people have sneaked into it? This data analytics running into half a page, which every dot means thousands of people. You cannot detect any abnormality when you draw a bell curve, which is based on 23,33,000. The correct procedure, if at all they were doing it, the correct procedure was to apply this process to 1,08,000 people. The first 1 lakh people in 2021, 22, 23, and 24. Probably the curve would have been able to catch 1,000, 2,000 people going up and down. Now even 1% is up, is into thousands of candidates. This Honorable Court has not tolerated, even if it comes to a conclusion that 1,000 people have entered into the system of this 1 lakh. which we are not able to detect, this examination cannot be sustained.
Well, that's one aspect about what IIT Madras has done. Now, what about how do you develop? Now you can develop the basic case that you have.
I'm demonstrating that IIT Madras can't be relied upon.
Because they have taken the entire body of 21.33 lakhs.
That's right.
And according to you, that data analytics should have been done on the restricted figure of 1,08,000 and compare that with 2021, 22 and 23.
So great. And Willard, the governing body member is the of NTA is the director IIT Madras. There is a conflict of interest. Willard.
No, but therefore you take it. I mean, what is at the highest? What does that lead to? Your argument is that the data analytics has been done by NTA itself.
Correct. That's right.
It can't be higher than that.
And apply.
That's because the director of IIT Madras is also on the governing body of NTA.
That's right.
Actually, he's not.
He's not, they say.
He's present in
But
the court on my request. He says he's not on the board of directors of NTA.
Oh, I see.
He was an outsider who's without expertise.
But anybody from IIT Madras who is on the governing body of NTA?
He was. Somebody else was.
Was means in the past.
In past.
Today, IIT Madras has nobody from IIT Madras in NTA.
When was that past? When he exited?
But the director who has prepared this report.
Mr. Solicitor, just sit for a second and ask them what the position is so that you can have a seat.
Were you a member of NTA? This is not the way it is done. Please don't do this.
I have not attended any board, not your
Member. He's not a member. Any other person who is a member?
Anand was a member. What's the previous guy?
When?
I step down strictly.
Subject to further verification. But the IIT, whichever IIT organizes JEE examination, IIT JEE for selection in, the chairman of that examination committee is ex officio member in NEET, NT. But the office, the director who has prepared this report is not the member, but some Mr. Gopal.
Now, The IIT JEE for 2024 was held by IIT Madras or who else?
IIT Madras. He is the chairman of that IIT JEE examination committee, but he deputed somebody to attend meetings of NT.
Oh, I see.
He ex officio is there to use his expertise.
So I'll just take it down. IIT JEE for 2024
was conducted by IIT Madras.
Yes.
And the chairman of IIT who conducts IIT JEE, ex officio is a member of NTA.
And what role does what role does NTA have in regard to the IIT JEE?
Nothing.
There's no.
He is
No, just ask the director.
NTA conducts JEE.
So the actual NTA, the actual IIT JEE mains are conducted by NTA.
Yes.
Oh, I see. So IIT Madras would only set the papers, or what happens?
No, they would conduct the examination. JEE advanced they conduct, JEE mains is conducted by NT.
So mains is conducted by
NTA.
By NTA. That's like the preliminary exam. The mains.
Advanced.
Advance is like advance is only in IIT.
May final.
This is only for IIT. Whosoever is intended to get admission in IIT, they opt for the advanced. Otherwise, all other
they are only the admissions are on the basis of IIT JEE mains.
The mains.
And IIT JEE advanced, NTA doesn't conduct that. So IIT JEE advanced is conducted by whom?
NTA.
No.
This is conducted by IITs.
IITs or one IIT?
One IIT. It is conducted by IITs. One become the organizing IIT. This year it was IIT Madras.
Okay, so like the CLAD.
Yes.
So this year, the IIT JEE advanced, the organizer was IIT Madras.
Correct. Okay. And he has gone into city-wise as well as center-wise analysis.
Now, when you said that the chairperson of IIT JEE is the ex officio member of NTA,
Governing body.
of the government, is ex officio a member of the governing body?
Yes, so governing body has no correlation with the activities of the conduct of the exam.
So the IIT JEE, the chairperson. So this time, who was the chairperson?
I took this time chairperson. He was the chair.
He was the chairperson. He deputed one Mr. Gopal Krishnan to attend the meetings on his behalf.
No, but who was the chairperson? The director of IIT Madras was the chairperson?
Yes. For G. Because IIT Madras was the organizing body.
So IIT Madras was the organizing body both for the mains as well as advance, or only for advance?
Only advance. Mains was conducted by NTA, by us.
Entirely. But IIT Madras's director was an ex officio member of the
governing body, which is a kind of a
NTA.
making.
Of NTA. And is he an ex officio member only for this year or generally?
He would be, whichever IIT conducts the exam. Of
for that year, he becomes a member of the governing body. All right, I got it.
But I must tell your lordships, my lord, that what is placed in the report is, my lord, for say a city-wise spread of top 100 rankers.
This time the director IIT Madras would be ex officio a member of the governing NTA, But he had deputed somebody else on his behalf to attend the meetings.
One Professor Gopal Krishna.
Lord,
And I have city-wise and center-wise.
so that I'm explaining.
But deputed professor or doctor?
Gopal Krishna. Professor Gopal Krishna. But if my learned friend is going on the question of bias, that may not help here. I have sat with him, my lord, I have examined everything which he has done. Yeah, I can show it to your lordships, and Lord, it is city-wise, center-wise, and at the national level.
Yes, Lord,
Just so that there is no.
That can indicate when your turn comes. Notice. All right, now tell us.
Without showing the document, Lord, that city-wise and center-wise, the first table is, my Lord, the bell curve of 23,000 people. 23 lakh people. The second table is city-wise top ranker analysis, the top 100, how top 100s are spread over across the cities. Then there is a table which gives
Can we do this, Mr. Huda, to understand your submission? Can we just look at the report of IIT Madras?
Yes, I straight away demonstrated.
Let's go straight there because
yes,
let us first understand what they have done.
Yes, that's great. Lord, may kindly see the reply filed by them on 10th of July.
Just one second. Serial number kaun sa hai bhai? Union of India.
Additional affidavit dated 10th of July filed on behalf of respondent number 2, Lord.
28 dated 10th of July?
Correct, Lord. That's right. Lord, this is respondent number 2. Annexure A, Lord. Page 12.
Page 950 तो है ही नहीं बोलता.
Is this a union?
It's analysis of the 17 candidates or no?
Lord, this annexure is data analytics of NEET UG 2024, annexure A.
Lord, it may be part of the petition filed by Shivangi Mishra. Item 7.1. That was the first.
Yes,
it is in Shivangi Mishra's case, my Lord, because they didn't file it in my case.
Yes.
Yeah, we got it.
But copies are served on.
Yes,
that is
copies are.
Report from IIT Madras, pages 12 to 18. Let's see that.
Yes. Now, you see, at page 12 is there's an executive summary given on page 1, and then the charts. Executive summary indicates they have gone all the way to explain. If I can read it, the executive summary.
Yes.
Marks distribution follows the bell-shaped curve which is witnessed in any large-scale examination.
Just one second.
Yeah. Executive summary, short summary. Marks distribution follows bell-shaped curve that is witnessed in any large-scale examination, indicating no abnormality. City-wise and center-wise analysis done for 2 years, 23-24, to find out if there are any abnormal indication. Analysis is carried out for the top 1.4 lakh ranks, given that the total number of seats across the country is around 1.1 lakh. This analysis is granular enough to indicate any abnormality had a large number of students gotten into high rank top 5% due to malpractice, or if students from a particular exam center or city were benefited. The analysis show that there is neither any indication of mass malpractice nor a localized set of candidates being benefited leading to abnormal scores. I would say this is beyond their brief, what they are stating here. D, there is an overall increase in the marks obtained by students E part. There is an overall increase in the marks obtained by students, specifically in the range of 550 to 720. This increase is seen across the cities and centers. This is attributed to 25% reduction in syllabus. That's not their case for them to say. In addition, the candidates obtaining such high marks are spread across multiple cities and multiple centers, indicating very less likelihood of malpractice. Well, if I can take just one moment here. NTA, the Government of India, in their reply is talking that they're attributing two reasons for this exponential inflation in the marks. Two reasons are there is 22 to 25% syllabus reduction and hence the inflation. Two, increase in candidates. Nowhere there is a whisper that there was increase in the syllabus that we have placed on record. If not more, at least corresponding. So, if I can say so, the reply is not giving a full disclosure for oblique reasons. If they are talking about deleting the syllabus, they should simultaneously talk about increase also. At least they should disclose it. I will show the increase part of the syllabus. I will come to it. So there is an increase and decrease both. But this IIT Madras is talking about 25% reduction. Probably they are not given the papers that there is an increase also. And why IIT Madras will not?
Let's look at the data.
Yes. Now kindly see the first table. This table, Millard, is for 23 lakh people. They say it is a bell shape. And any large examination will have a similar kind of a shape. And hence, there is no red flags. Now, starting from extreme right, where 720, now Millard, it is going up to the marks. Now, at every stop, there are thousands and thousands of people. This one line, which encapsulate about 24 lakh people, cannot give them any abnormality if 10,000 have gotten into this system through a back door and there is an inflation. Inflation is admitted. Leak is admitted. They are trying to justify it that it should be the same curve, and it is the same curve. So this is no indication that there is no abnormal. That is my respectful submission. Because of the data is too large, which can't be caught. Granular variations can't be seen with this large data.
Yes.
Now, may kindly see the next table. They say the city-wise top ranker analysis. plot of the marks obtained versus number of candidates for all the candidates who took the examination. Similar analysis was carried out by NTA for every city, and the results followed the same distribution. This was verified by IIT Madras team. This further strengthens our view that there was no major abnormality. There can be abnormality, but there is no major abnormality which can be caught by this system if this Python software is run through 24 lakh students' data. Now, we can see center-wise top ranker analysis, which they say that there are city-wise. There are 571 cities. They say first top 100 are evenly spread. And then the data they give is only with regard to 17 students. Bangalore, Karnataka 5, Lucknow, Uttar Pradesh 4, Kota, Rajasthan 3, Tamil Nadu 3, Patna, Bihar 2, total is 17. Why are they shying away? If they have run it for top 100, they should give for top 100. That will include Hardayal School, Bahadurgarh, which had 8 candidates from the same center. Now, they are leaving us in darkness because they have the data, we do not have a data. So whatever they are saying, we are trying to analyze and find that is it correct or not. Now, the same story runs through all their tables. Can you see the next table?
I can give, there is no difficulty. Just to
all right. I'll read the narration also.
Only a minute, just to give the context. This chart shows that out of students who got first top 100, and we are not counting those 1563. Please don't count them because they become a separate class.
My only limited objection is why send only for 17 people? Why don't they give a data for 100? Top 100.
I'm answering that. Please allow me to. You listen to it. In Bengaluru, just to show the difference, in 23 there was 1. Here it is 5. Maximum in India, the city which got 100 ranker is 5 in Bengaluru, Lucknow 4, Kota 3, Namakkal 3, Patna 2. Rest are 10101.
But do you have the breakup of the top 100 ranks?
Yes.
Top 100 ranks, if you can give us what cities do they come from? Because we have now got the data for the 17, 5 and 4, 9 and 3, 12 and 15 to 17.
Rest would be 1010.
If you can just give us in a chart, you can set it out and give it to us and give it to the others also. That if we take the top 100, which are the cities from which they are?
Our counter affidavit at page 118, we have shared the 100 side also, and we have based it on.
Just give it to us separately right now.
Yes.
You have it right now, just give it to us.
Separately, it is annexed to our counter affidavit.
Where is it? You just page.
Your counter.
Page number 118.
Counter of NTA.
Item 7.
Vanshika, yes, sir.
118.
Yes. 100 कहाँ से बने?
So अलग-अलग with 91.
Yes, spread to 91 places, but these 5 are top. Bangalore has maximum students, 5 who are in the first 100. Rest would be 101010, etc.
We said 950, no?
Affidavit on behalf of NTA?
Yes, my lord, 118 annexed R19.
A19.
R19. PDF page 121.
Replying.
$121.
PDF 120.
Hey, 121 is some wakalatnama.
Annexed
analysis of top 100 can
R9.
Counter affidavit on behalf of NTA?
Additional affidavit of NTA.
Additional affidavit of NTA.
The petition number would be Petition 335 of 2000.
Correct, correct. So one Binod Kumar Sahu is the deponent?
Yes.
Right, got it.
There we have got the annexure A1 is a performance analysis of 17 candidates of Patna, Bihar.
Yes.
A2 is copy of screenshots of messages.
Correct. Same.
Now, which is the chart that you're referring to?
118. But in the entire country, the analysis of top 100 candidates.
Where is that actually?
That exactly, my lord, annexure
118, my lord, annexure 19, R19.
118. पेज नंबर तो 118 होगा.
Additional. It's continuous page PDF 1070. 1070.
There is no top ranker. This is the additional.
Sound. Part transaction they are. Shastri organization.
So, my lord, here given center-wise toppers for all 100.
Right. So first is Guntur.
That's it.
Lord, can your lordships come to 121?
Yes, we got it.
We have 121.
Yes.
Please see Lucknow.
See which one?
Lucknow, my lord. Uttar Pradesh, Lucknow, my lord. Left hand side, first column, Uttar Pradesh, Lucknow. 2, 1, 1. Your lordship gets, my lord? Lucknow, Uttar Pradesh is the state. Lucknow is the city, and SDSN Mahavidyalaya is the center. From that center, out of 100, 2 candidates fall into 100, first 100. Then in Lucknow, Loyola International, 1 student, and Uttar Pradesh, Lucknow Central Academy, 1 student. Total up to 4. And therefore, in the report of the IIT Madras, they mentioned Lucknow as 4.
Lord, may at the same page, Lord, may kindly see at page 120, there are 9 people, 8 people from Jaipur, which they have not captured in the table. Kindly see the Jaipur, my lord. Page 120. Jaipur alone has, my lord, 1, 2, 3, 4, 5, 6, 7, 9 people.
Sir.
They have captured 2. They have not captured 9.
You're right. 1, 2, 3,
Nine.
4,
It is
5,
9.
6, 7, 8. 9 probably.
No, 8 seconds.
7 people from Bihar, my lord, in this.
Uttar Pradesh, we get 2 and 1, 3 and 1, 4.
Yes.
That 3 from Lucknow, 2 from Noida. Lucknow 4. Lucknow 4, no?
But the purpose is to show that they are spread over. That in Lucknow, there are only 4 out of total 23 lakhs who appear. But just to show that if there would have been any leakage or malpractice, in one center there would be a spike. That's the intention.
Bihar, there are 7, right?
Yes.
Bihar, there are 7. Yes, my lord.
State-wise, Bihar, there are 7.
Yes,
right?
Yes, my lord.
Then Haryana, how many?
Pradesh 7.
Gujarat, there are 1, 2, 3, 4, 5, 6.
Haryana, Haryana 3, 4, Haryana 4, my lord. And Lord, may kindly notice Haryana 4 is in a situation, if I can be given a moment here.
Yes.
There was one Hardyal school in Bahadurgarh where 8 people were from the same center. And the story of that center is, my lord, the paper distributed in that center, 500 odd student, was taken from Canara Bank. Paper was
That is a different issue.
That's a different issue, but I'm showing it has a relevance.
But Haryana, there are 4. There are 4 in the top 100.
Lord, there were 6 people in the top, which are not, they are not there now. Because what happened, my lord, in Bahadurgarh, Lord, that's one other glaring thing I just want to state here. NTA never disclosed it. That in Hardyal school, Judge, the question paper taken from Canara Bank was distributed. That paper was taken. There was absolutely no delay in distribution of paper. The principal of the school is on record on YouTube. Even here it can be shown. She says that we collected paper from SBI as well as Canara. Ultimately, the instructions came that you distribute paper from. Allow me to state it.
It's a different issue. We will not
Different issue that which you have never disclosed on affidavit till now. And I will demonstrate in. That's a very clinching issue, which they are getting agitated on that. Paper taken from SBI as well as Canara both. The paper was distributed, which is taken from Canara Bank. The entire country was giving the paper taken from SBI, but Hardyal School, Bahadurgarh, paper was given, distributed, and ultimately full time was given and paper was taken on the basis of Canara Bank. Answer
that we should call it from.
Now, my lord, what happened is, just if I can complete it, what happens is the principal says that after about 40 minutes, I conveyed it that we were told Canara Bank and now the students are attempting Canara Bank question paper. Then the instructions to her was that, all right, if it's already 40 minutes, so let them do Canara Bank. They did Canara Bank. Ultimately, what they did not disclose it to anyone, but they gave grace marks to everyone in that school. And because of those extra marks, 6 people got 720 out of 720. 2 students from the same center got 718 and 719. Thereafter, Lord, this was a grace marks given.
Of course, thereafter, a fresh examination was held.
No, Lord, Lord, that is impinging upon the entire system they have. Now, initially, they arbitrarily gave grace marks for which they were not entitled to at all. Now, this is how they have given grace marks across the country. There was absolutely no justification because they have not come clean on that. Here, they should have said, in Bahadurgarh, a different paper was given. That is why we are holding a re-exam. Fine. First, they said that there was a delay in distribution of paper. There was a loss of time and hence grace marks. When they were caught in this court, then they appeared before the Honorable Other Coordinate Bench and said, now we are having a re-examination. So please do not go into how we gave the grace marks to this 1,561 people. I'm sorry, 1,563. So the question that how they gave grace marks to 1,563 people on account of loss of time has not been examined by this Honorable Court. They, in their reply, they say that the issue stand resolved because we have had a re-exam. My question is, my lord, that how in the first instance they identify 50